as we're marching along. Maybe we'll slow down. Maybe I'll have you participate in a couple of the cases from this chapter. I just didn't want to fall too far behind. So we're done with the two big chapters. We're done with the court system. We are done with the Constitution in an hour. I mean, who else completes the Constitution in 1 hour, right? Pretty good. All right, what are we going to do next? We are going to talk next about torts. And by the way, there are 2 chapters on torts in the textbook. Chapter 5 is what we're covering today. This is intentional torts and negligence. Chapter 6, which we'll cover next time, is product liability, or strict liability, which is going to have, which is its own chapter, but it's a continuation. What is a tort? We read the whole chapter. Did anyone understand what a tort even is? In like their own words? Is a tort a crime? Can it be a crime? What do you think? I mean, the word tort just means a wrong. I mean, it's a French word for private wrong. And that basically tells a story. It is a private wrong. Now, to my other question, can a tort also be a crime? Yeah, it can be. We're going to talk about things like false imprisonment, trespassing, or whatever. Yeah, it's, I get injured by that. I'm a private party. I may be able to sue you in a private lawsuit, but some of those same actions could also be criminal activity for which criminal charges. So there's overlap here. So what is a tort? It is a wrong. It is a private wrong, and it comes in 3 different broad categories. Ready? The first 2 are the ones that we're covering in this chapter. Intentional torts is one type of tort. Negligence or unintentional tort is the second category. And the third category is strict liability, which we'll introduce in this chapter, but we'll cover in more detail in product liability when we go into chapter 6. Everyone with me? Intentional torts, negligence, strict liability are the 3 types of torts. So, what happens if we have a lawsuit based on a tort? Well, here, the injured party, and when I use the word injured, I don't just mean physical injury, it could be an economic injury. So start thinking about things from a business law perspective. Yes, it may be a physical injury, it may be a car accident, or it could be an economic injury where someone, stole trade secrets, which is a tort, right? So an injured party brings what? A civil lawsuit, because it's a private wrong, it's not a criminal act. You could be criminal charges, but we're talking about a civil lawsuit. So an injured private party brings a civil lawsuit for what? Not for putting someone in jail. Can't do that. I can't say I'm suing you and I want you in prison. I'm not the government. All I'm really looking for is compensation for something that you did either to me or to my property. Okay? That is where the word tort comes from. And tort damages are usually compensation, monetary damages for the most part. And by the way, it's possible that someone committed a tort against somebody, and it is so serious that that individual actually dies, right? And there would be criminal charges to that. But it is also possible to bring a private lawsuit. And the private lawsuit here would be against the defendant based on wrongful death to recover damages, right? So you could have the criminal aspect of that case proceeding along with side by side or after the fact a civil lawsuit based on that same wrong. Okay. The first category we're going to talk about are intentional torts. So, just the word intention, right? What does that mean? What does it mean to do something intentionally? Purpose. Exactly, purposely. It wasn't by accident. I meant to, kind of, right? And we're going to see how that differs from unintentional torts or negligence, which I like to say, oops, didn't mean to, but it still happened. I'm still going to be liable, but it's a different degree of intent, if you will, right? So intentional torts are a category of torts that require the defendant to have the intention to have caused the plaintiff's injuries. And, we're not going to go through every single possible tort that's out there, but we're going to look at a wide variety of them. And we're just going to kind of go through and say, oh, yeah, that's a tort. Yeah, that's a tort. For example, the first one, an assault. What is an assault? An assault, legal definition, is the threat of immediate harm or offensive contact. An assault is any action that arouses a reasonable fear of imminent harm. Word imminent meaning about to happen. But here's something interesting. Actual physical contact is not necessary, right? Most of the time when we think of somebody assaulting somebody, it means that they hit them or they did whatever. Could be criminal too, by the way. There's criminal assault and there's non-criminal assault. But really, actual physical contact is not necessary. It could still be an assault. Technically, yes, because what is an assault? The threat of the harm. So it could be, like the example that most people would give is that if someone walks up to you really close, right, and you could say, let's say it's me, I'm not a huge person, but if someone comes and they're a lot taller than me and whatever, and they're really coming at me, and I just think, oh my God, this person is going to do something to me. They don't do anything to me. However, they back away, but that threat causes me to just sort of fall back or whatever and have an injury. That's still an assault, right? That fear, that apprehension, that threat of imminent harm is itself an assault. But an assault usually comes with a battery, right? We're used to thinking assault and battery. Because the battery is the actual contact, that unauthorized, meaning I didn't say do this to me, harmful or offensive physical contact with somebody else that causes an injury. There can be direct or indirect physical contact between the victim and the perpetrator, and it may or may not accompany assault. And you say, wait a minute, you can have battery without assault? How could someone injure me without me not knowing? Sure they can. They can hit me from behind. I wasn't afraid of it, but I wasn't fearing it, but it's a battery nonetheless, right? So these are sort of legal definitions of assault and battery, which are intentional torts and could also be a criminal charge as well. Oh, and by the way, there is something in the law referred to as a doctrine of transferred intent, which basically says that if someone actually wanted to injure one person but wound up injuring another person, the law will say that the intent of that person moves from the target to the actual victim, and the victim can sue in tort. So yeah, imagine a bar fight where you're gonna hit the person next to you, that person ducks, and you wind up hitting somebody totally different. Is that an assault and battery? Sure is. Doesn't matter that you didn't want to hit that other person. You could be sued for tort for assault and battery under this doctrine of transferred intent, even though the intent was not to hit the third party. Okay, nothing surprising there. Another example of a tort is false imprisonment, which, by the way, when you read the definition, intentional confinement or restraint of someone without authority, without justification, and without that person's consent, by physical force, by barriers, by threat of physical harm, by false arrest. What does that sound like in the criminal law area? What is that? Isn't that kidnapping? Right? That is a crime of kidnapping. So yes, that same action is an assault, a false imprisonment, which could also be the crime of kidnapping. So what is false imprisonment? When you don't have the authority or the justification to keep somebody, but you're doing it anyway, without justification. And that person could have the authority to sue you. And where this comes up in the business law arena is Sharma, or what used to be referred to as merchant protection laws. And basically it wound up being an exception to that. And basically it said, look, merchants, that's such an old term, shop, whatever, an owner of a store can actually stop, detain, investigate who? Suspected shoplifters without being liable for false imprisonment. When? If they were reasonable. Meaning, they had a reasonable ground for suspicion, they were only keeping somebody for a reasonable amount of time, and the way that they conducted their investigation was done in a reasonable manner. Okay? So that is why everyone that is held for possible suspicion of shoplifting where it doesn't pan out and it was a mistake isn't able to sue the store, because if the store conducts this in a reasonable fashion, it is basically an exception to a charge of false imprisonment. Yes?
I have a question.
Sure.
Does it mean that you, as the owner of the store, can stop the shoplifter, suspected shoplifter, physically?
Well, again, facts and circumstances. You basically should, how much force should you use? You should say, would you step aside? And the person, I'm not doing it, and he runs away. Well, you can't, say, let me just get 3 people and, whatever. It doesn't, no, you have to do this in a reasonable fashion. You could call it, you can't use self-help or force or, so you have, so, I'm sorry, the question was, can you,
as the owner of the store, hold them physically and touch the person?
Well, it depends on if it's just, would you please step over, and all you're doing is, that's fine. But if you should
never stop like that.
What?
Shoplifter never stop like that.
Well, that's just the thing. It's reasonable. It's such a, it really depends on the circumstances. I'm going to talk about a case where it's obvious. Okay. It's awful. But, between just gentle escorting to that case, there's so much in the middle. And the question is, where do you cross the line of being unreasonable? And it's such a facts and circumstances.
Can I ask you one?
Sure.
Do the security guys that work in the mall, do they have this right to physically hold the person?
Physically depends on how much force. Physically, I will escort you. Yes, up until a certain extent, if there is valid suspicion. Because the thing is, if you let someone go, you lose the evidence, right? So yes, that's their whole purpose. But how much force, how much physicality is the question. That, again, I don't have a bright line answer to, except that you have to be reasonable in doing it. And you have to sort of, they have to walk a fine line, and, as the perpetrator, someone who's probably innocent, has to be very careful, because it's not the same thing as a resisting arrest, because we're not talking about a police officer. It's not that kind of authority. But it is still some authority. You're going on to somebody's private property to shop. You're submitting to some rules over there. But the question is, how much have you submitted to? Certainly not as much as the Walmart case, which was a despicable display of authority. Someone talk to me about the Walmart case. Yes.
It was a story from, I think, 1996. This couple and his parents were shopping. They were only there for 5 minutes. The loss prevention officer stopped him.
Where was he at the time?
When he was leaving.
No. But do you remember what department this gentleman was in?
No, I don't.
He just happened to be in the women's
In the women's? Okay, that's probably one.
Yeah.
But he left after shopping there for 5 minutes, and the loss prevention officer came up to him and asked him to go to the management office.
Right.
They told him to undress, and then he also had a surgical wound Band-Aid, and they told him to take it off.
And he said, no,
yeah,
I've just had surgery.
He had surgery, he couldn't take it off. And they didn't care, they took it off, and I guess it was a suit. He filed a complaint saying false imprisonment and assault.
And did they win?
I believe so, yes.
Because look at, this one is kind of easy. Were there reasonable grounds for suspicion? Arguable. What's a guy doing and the woman's doing? He could be buying a gift. Is it reasonable? I don't know. Even if you sort of give him that. Suspect was detained for a reasonable time. Well, it took quite a while. But the problem here was a reasonable time. Really, do you expect someone in those 5 minutes to have undone their wound and put something, put a piece of jewelry in? This is bizarre, beyond anything that anyone could ever imagine. Obviously there's improper training. It's just, an overzealous employee. But as we'll learn when we talk about employment law, is if an employee is acting for the employer is going to be liable for actions that the employee is conducting during the course of their employment. And here, the shopkeeper's privilege, meaning this exception to false imprisonment did not apply because it was a search or detention that was done in completely an unreasonable fashion. Yes?
So say someone was shoplifting
I see.
like that, it's
I
like,
see. Yeah, I mean, that's a great question. I would say that there could be some, there might be liability, That's sort of the muddier example of both sides are guilty to some extent. There's a tort on both sides. So I'm not saying that the individual who, lifted something is not guilty of a tort. They are. But it could be that the shopkeeper, the store is also, because again, the amount of force is unreasonable. So how this gets settled out in court, and we'll see there's comparative and contributory negligence. Both parties are partly at fault here in that scenario. Is there another question? Yeah.
Yeah, I have a question. Shoplifting is only if you take it outside of the store, right? Because if they catch you stealing and you put it back, is that not shoplifting?
I hesitate to answer that because it depends on the wording of the statute. Because taking something with the intent to, if I, and how do you prove that? I mean, what reason do I have to take something and put it in my pocket? I would argue, well, I always wanted to pay for it. I just didn't want to put it into the cart, the shopping cart, because it would fall through, right? So, it's such a factually driven sort of a thing. Why did I take a pair of socks that and put it in my pocket as opposed to, but I meant to take it out and I did. Did I change my mind? Did I, or did I just put it there for safekeeping? I don't know. I think you have to sort of look, what does it say to shoplift? What does the state statute says, and then how do you interpret it? So you start to see that, what was the value of the item? What was it likely? Would a reasonable person believe that the reason it was in the individual's pocket, even though they didn't leave the store yet, was that they only put it there because they wanted to pay for it, but they just didn't want it to fall out? Or it was on sale and I didn't want someone else to take it, it was Black Friday and I didn't want anyone else to take it, and that's the reason. Who knows? It's very, very factually driven. And I would say it's hard to answer that question because states define what it means for that to be, a tort or a crime. But good questions, not clear answers. All right, we'll just run through a few more that are intentional torts, and again, there are a whole variety of them. Misappropriation. Anytime you see the word misappropriation, it means stealing. Okay, taking something that doesn't belong to you, taking somebody's right to publicity. Attempt of one person to appropriate, to take a living person's name or identity for commercial purpose, also called a tort of appropriation. So, this could just be assuming someone's identity. It could be any number of crimes, but also a tort because you're actually profiting off of that, right? So what is the recourse from a tort perspective? Well, here, the recourse is that, the individual that is doing this is, can be sued by the actual person. It's like you sometimes see someone selling a product under the name of a celebrity, right? I know Paul Newman and all of that, those are legitimate, but someone like marketing something under the name of a celebrity. If it's a famous chef, you might just say, well, I'll sell more bottles, but what are you doing? You're using someone's identity to profit off of them. So if that individual sues you, what are they looking for? Well, yeah, they may be looking for profits that you got based on their name, but what they're typically looking for is something else. They're looking for you to stop doing that. And when you go to court to make someone stop doing something, it is called an injunction. Obtaining an injunction to prevent further unauthorized use of your identity, right? So yeah, it's a tort for which the recourse might be going to court and stopping someone from doing it. And number two, saying, you don't have my authority to use my name. And number two, any profits that you make belong to me because no one would have bought that lousy spaghetti sauce if you didn't put my name. And other things like invasion of the right of privacy. Obviously, we know that everyone has a right to live their life without being exposed to certain things. This is a funny one, and this is one that came to light when we talk now about every phone has a camera, But think back 10 years from now, 10 years ago when phones didn't. And this notion of people, taking pictures without someone's permission and things like that, locker room photos and stuff like that, which is highly, creepy and disturbing. So it's not like you're putting something out there that is true or untrue. The point here is that are you invading someone's privacy? And that right there is a wrong, is a private wrong for which there are civil damages. What else? This is one that's sort of significant. Defamation of character. What is that? It's basically ruining someone's reputation by saying something about them that is not true, right? In order for it to be defamation, it has to be false. If you say something about someone that hurts their reputation, but it was actually true, it's not a tort, right? So it's a false statement made by one person about another, and defamation could be either oral or written. So if someone says something orally, that's called slander. And I know this is what the CPA exam loves. This is terminology that we need to know. What is oral defamation of character called? Slander. What is written defamation of character, something that's portrayed in the media, called? Libel. Okay, everyone with me? This memorization. Well, how do you prove that someone has committed the tort of defamation of character? The defendant has to have made an untrue statement. If it's true, it is not technically defamation of character. And it could be intentional or it could even be accidental, actually. You could have defamation of character happen either way. And by the way, this doesn't just have to be about an individual, it could be about a business, right? Disparagement, false statements about a competitor's product, services. How overzealous does someone get in their advertising when they try to put down the product of their competitor? If they're saying untrue things, well, Coke only puts so much into their product, or Pepsi puts that, that is disparagement if it is untrue, because you are, all is fair in love and business, but you can't cross a line, which is basically saying something about someone else's product that is actually not true. And we can go on and on. Intentionally, intentional misrepresentation, defrauding someone, lying and taking their money. Well, that's also a crime, but there is also the tort of fraud, right? Fraud is a tort. The authorities may or may not bring criminal charges, but a party can sue another party. Well, you took money from me by telling me that this was a valid investment. It wasn't. This is all nonsense. You gave me a faulty prospectus, blah, blah, blah. I am suing you for fraud. Because fraud is the intentional defrauding of a person out of money, property, or something of value. Crime, as well as a tort. You don't have to memorize everything. You just have to recognize a tort when you see it, right? Intentional infliction of emotional distress. You see this in a lot of cases. It could be assault, it could be battery, and we're going to throw in the fact that you inflicted emotional distress on me as well. Because, every tort, every wrong can lead to more civil damages, right? So extreme and outrageous conduct that intentionally or recklessly causes severe emotional distress to another person. Remember the Walmart case? That was a case of false imprisonment tort, but why couldn't the tort of intentional emotional distress be thrown in right along with it? Because surely the facts as we've seen it would justify that kind of a charge also being thrown. And there are others, and we can go on and on and on, but we're going to try to sort of move on to the next category, right? First category of torts are these intentional torts. The next category is unintentional torts, otherwise known as negligence. Okay? So what is negligence? Negligence is basically a legal doctrine that says that someone is liable for the harm that they cause, and circle this word, that is a foreseeable consequence of their action. So what is negligence? Negligence is doing something or not doing something that someone who is a reasonable person, and by the way, when we read the law, we always see reasonable person. What do you I have yet to meet this fictitious, it basically is a standard. What would a run-of-the-mill Joe Smith, Jane Doe do? What would a reasonable person do under the circumstances or not do under the circumstances? So for example, it's raining outside. Not today, but it is. It's raining outside. And it's late and it's starting to sleet. And even though the speed limit is 45, would a reasonable person slow down? Would a reasonable person not be texting at the same time? Would a reasonable person, not be applying their makeup? What would a reasonable person do under those circumstances? Now, if that person caused an accident, they didn't mean to. The last thing they wanted to do was hurt somebody or their property, but the fact is, did they engage in behavior that someone else who was prudent and reasonable under those circumstances not have done? And if so, is that negligence? Right? That's how you measure negligence. So, bringing a lawsuit, private, remember, there could be criminal negligence. We'll get to criminal law later. We're talking now about civil negligence, private parties suing each other for behavior that amounts to negligence. Well, how do you know if someone has been negligent? Well, in order for someone to be negligent, the defendant has to owe a duty of care to the plaintiff. We'll talk about what that means in a minute. The defendant has to have breached that duty of care. The plaintiff has to have suffered an injury, and that injury had to have been the result of either actual or proximate cause of the plaintiff's injuries. Next to this, you can write the word causation. Did the defendant's behavior actually cause the plaintiff's injuries? So those are the elements, and it's an important slide because it is summarizing those 4 or 5 elements. Now let's talk about each of these elements. The first one, duty of care. Where does that come from? It's an unwritten rule. I gave you the example of driving too fast or negligently. I don't know, I didn't sign anything that said when I got my driver's license, I recognize that I have the duty of care. I will not go over the speed limit. I will not text and drive. I will not put on my mascara. But no, I didn't sign anything that said that. However, it is assumed. The law assumes that we, individuals, businesses, owe each other a duty of care to not cause unreasonable harm or risk of harm. And I keep talking about this reasonable person. Reasonable person is a test used to determine the duty of care. What would someone, and this kind of could happen in a case where you said, well, wait a minute, the driver was 75 years old. Okay? But anyone behind the wheel that has a valid driver's license, it has held to a reasonable care standard. So whether you're, wait a minute, he was only 18 and he just started driving. Okay, but that's no different than someone in their 40s driving a car, right? So that a reasonable person is a general broad standard that you have minimum understanding of what should or should not be done under certain circumstances. And when we talk about negligence, we're going to talk a bit about one major type of negligence, which is malpractice, right? And malpractice could be, most of us will think of medical malpractice, but it doesn't have to be. It could be legal malpractice, and oh my God, accounting students, it could be accountant malpractice, or not, what would a reasonable professional standard be under those circumstances? Did you abide by the standards, did you look at GAAP, or did you make up your own standards, right? What would a reasonable professional have done under those circumstances? So a duty of care is a duty not to be negligent based on what a reasonable individual would have done under those circumstances. What is a breach of that duty? A breach is to violate something, right? Breach of duty of care is to fail to exercise or act in a way that a reasonable person would have. We're going to say that a reasonable person would have slowed down under those circumstances. The law is going to assume that you had a duty of care and you violated that duty of care. You breached that duty of care. What else? Negligence also requires that the plaintiff be injured in some way. So, and by injury we mean personal injury to property, personal injury to the body of the individual, but you cannot recover in negligence. It is not a theoretical lawsuit. If there were no damages, there was no injury, there is not a sustainable lawsuit because there are going to be no damages, right? I mean, if someone's driving too fast and texting or whatever, and they almost caused an accident, but they didn't really, there may be a criminal issue there, you may get a citation or whatever, but I can't take someone to court and say, oh my God, you could have, it could have been. No damages, right? Unless this was some severe, if I can make a case for some severe infliction of emotional distress, I don't see a basis for a lawsuit because there was no injury that happened. And how much the damages really does depend on the type of injury. And the book had an interesting case, like what if someone got injured and the injury was to their hand, right? And, I use my hand. I use my hand to do all kinds of things. But what if after surgery or whatever, I'm back to doing everything that I do in life. I can write, I can type, I can, put on mascara, whatever. All is well in my world. But let's say the person that got injured was a baseball player, okay? And that baseball player, it's testing my knowledge of, the curveballs and whatever pitches that they throw, really affected that ability. I mean, the guy had, pitching average of blah, blah, blah. He was known for X, Y, and Z, had a $15 million contract a year. After that injury, after everything was done, he can go about his life. However, those curveballs are not the same. It's just, he lost it because it just, it was such a bad injury. The damages there would be very different for that individual versus me who can go on with my life because, I don't use my hand to throw baseball, right? So that's a distinction. So these cases are really, really pretty individualized, not only in terms of whether or not there's negligence, but what is the measure of damages in any particular case. Oh, let me think about the Seattle case. Is the award of damages, the firefighter case, right? Anyone remember? What do firefighters do when there's an alarm of fire? What do we think about this? They go down the pole and they get into the thing and they do their thing. So what happened in this case? And firefighters, as we know, it's one of those jobs where nothing happens. You sleep, you get up in the morning, nothing happened. But boy, when it happens, it's whatever. So the firefighters are on overnight duty. You're expected to sleep somewhere, but his bunk is right next to the pole. He got up in the middle of the night to use the bathroom, and what happened? He fell down the pole. And the question was this negligent design by the firehouse, by the city? And this is a case against the city of Seattle in Washington. And by the way, this firefighter sustained rather serious injuries. And the jury awarded him damages, significant damages, and they were high. And the city appealed and said, this is too much. And the court, all the way up to the Supreme Court of Washington, says, it is what it is. A reasonable trier of fact could have found that it was legitimate to award damages. And, you're talking about a young guy that, has lost tremendous quality of life and so on and so forth over something that was clearly negligence. Nobody intended this to happen, but to ask someone to sleep right next to, an open hole, when you get up from your sleep, you're not thinking rationally, and my God, it was foreseeable that this damage could have happened, or this injury could have happened. And you know what? Award of damages, even if it's in the millions of dollars, it stands because a jury found that that was reasonable under the circumstances. So that was basically the takeaway from this case. And look, if we were in law school, we could be talking about causation for weeks on it because there's so many cases about what is causation, right? Because remember, one of the things you need for negligence, the last thing you need for negligence is you need the duty of you need the duty of care, you need to breach the duty of care, you need damages. But the last thing is you need causation, meaning what the defendant did was actually what caused the injury to the plaintiff, or was the legal basis for what that injury was. So a person who commits a negligent act is not liable unless you can prove that their action is what caused the injury. Or, how far down the line is my negligence going to be responsible for someone else's injury? For example, you're driving your car, and I was a little negligent. I just didn't look in my rear view mirror, and I just tapped somebody's car. Just a little fender bender. We get out of our car, we're looking at the damages and so on and so forth. And while this is happening, lightning, it starts to rain, lightning strikes, and it strikes the other person's car, and the car is demolished. And they sue me for the damages to their car in total. And the question is, what am I liable for? The little dent that I caused, the fact that the act of God, and the other person is arguing, well, you caused it, because if you didn't hit me from behind, I would never have been stopped there. If I had never been stopped there, the lightning would never have hit, so you're responsible. And, that's this notion of proximate cause. How far do you take it? And the law says there has to be some point where you're no longer liable. And most people, no, you're not liable. It just happened. Go to your insurance company. We were stopped there simply to look to see, and I got to give you a couple $100 for the little tap that So again, causation is one of those slippery slopes, and we can spend hours talking in different cases. But the point here is that, it has to be some linkage between what the plaintiff did and the defendant did to the plaintiff's injury. It's like we're talking nothing more about video games and so on, it seems, because this is your second video game case. I don't mean to laugh about it. It was actually a very, very sad case of negligence, or a lawsuit based on negligence. So here's, sadly, another case from 2002 that is talking about a school shooting. And here, what happened was you have, a junior high school kid or something playing a bunch of video games. It's shown, gets his hand on a gun, goes to school, opens fire, winds up killing 3 people. Okay, and awful. But look at the lawsuit. The lawsuit is not against the individual. The lawsuit is against a company, Meow Media. Are the video and movie producers liable to the parents of these 3 children for putting these violent games and movies out there? And is there a link between, even if you can show that they had a duty of care to be, reasonable people and not put stuff out there that could cause injury? And let's say that even if they breach that duty, and obviously there is injury, 3 people have lost their life. The question is there causation? Is there, first of all, before we even get there, is there even a duty of care? These things are out there. You could put controls on them, you could put PG-13, NC-17, whatever you want to put it out there. But are we going to hold people liable? And courts here said, look, and again, it went up all the way up to the 6th Circuit Court of Appeals at the federal level. And the court said, awful case. Obviously, you want someone to be held accountable, but we're not going to say that, there obviously might have been something in the psychology of this child. Other people play this game and they're perfectly fine. How can you say that, again, it's a very slippery slope. What is the duty of care? Is it that, anything that even remotely looks like violence is going to be outlawed? So, it's partly freedom of speech, it's partly a negligence ground, and we're going to say no. We're not going to hold. And there have been other cases like this where you try to put up a really good case and say, no, there's a connection, and the courts are going to say, no, we're not going to, we don't see the connection between one child somewhere in Ohio or wherever this case took place, doing this sort of playing these games and doing something horrific versus thousands of other people that are just using this as an entertainment or an escape, maybe in poor taste, but it doesn't rise to negligent behavior by these manufacturers of these video games. So, another sort of interesting legal case for that reason. Questions so far? All right, let's talk about professional malpractice, right? We said that that's sort of, negligence. So liability of a professional who does what? Who breaches his or her duty of ordinary care as it relates to that profession, also known as reasonable professional standard, right? If you're a reasonable physician, for example, and someone comes before you and describes symptoms, I have chest pain. And by the way, I think it's traveling down the left side of my body. And the physician says, what did you have for dinner last night? Oh, I had a cheesesteak. Well, there's your answer right there. You have indigestion. Go on home. Wait a minute. If you go to a doctor, I'm not even a doctor, but if someone comes to me complaining of chest pain and a pain, what does that symbolize? Possibly a heart attack, right? What should I do? Would a reasonable person, a general practitioner, and the physician might say, well, wait a minute, I'm not a cardiologist. Oh, wait a minute, shouldn't a family practitioner, even nurse practitioner, even Joe Schmo have known that these are possible classic symptoms of a heart attack, and you just don't dismiss it as indigestion, right? So again, it comes down to reasonable professional standard. What would someone else in that, obviously that physician feels terrible if he had to do it over again. He would have ordered that EKG, but, it's still negligence in not having done that, because ultimately that led to potentially a death that could have been avoided. Yes, it's possible that you could have negligent infliction of emotional distress in addition to intentional infliction. So you could have negligence with emotional distress as well. It's not typical, but it could be that the negligence rises to a very, very high level. And I'm just going to throw out a little bit more terminology here. No class is complete without a little bit of Latin. That's what business law is all about. The first one is something called negligence per se. And we find ourselves sort of using legal terms. Well, that was not per se offensive, right? We use terminology like this. Do we even understand what it means? Per se means on its face, it's obvious, right? Violation of a statute or an ordinance constitutes a breach of a duty of care. Negligence per se is if you do something, it's negligence by definition. And an example might be, for example, a law or an ordinance that says that if you don't clean up your sidewalk within, a half a day of a major storm, if anyone slips and falls, you're negligent. And you might say, well, I was out of town. I was vacationing in Bermuda. Why am I negligent? It's negligence per se. You have an automatic duty of care, right? It's built in to the law. Per se negligence means automatic negligence. So there are a few examples of that. And my favorite, which every law student always remembers, and maybe you, as accounting students, at one day have to take the CPA exam to etch into your memory, is something called res ipsa loquitur, which means the thing speaks for itself. So this is a type of negligence where the defendant had basically full control over a situation, and the only way that the injury could have happened was a defendant's negligence. There's just no question about it. The thing speaks for itself. And I think this is probably the example in the book, which is a fairly typical example. Someone goes in for surgery. They have their gallbladder removed because they have pain of all sorts. And, the surgery goes really well, but they're still having pain. It just doesn't go away, and they go and they talk to a bunch of different people, and now it leads to an infection, and they can't figure out why. And finally, someone does an x-ray. And you know what they find? A surgical instrument was left in there. Is that negligence? I don't know. I've talked to a lot of surgeons. I would say leaving a surgical instrument inside the body of the person you were operating on is negligence. Hands down. Now, do you have to go to court and prove all of that? No. That is res ipsa loquitur. No one else went into the individual's body except that one surgeon who performed that surgery, right? It's clear professional malpractice. It is clear negligence because it is impossible for the causation to be anything else but that's it. Right? We don't open up our bodies for no apparent reason. It has to be for a surgical procedure, and the only surgical procedure the individual had was the gallbladder. So remember things like negligence per se, violating a statute is automatic negligence, res ipsa loquitur, the thing is so obvious, it is, it's on its face negligence. What else? Gross negligence. We'll talk as we go through various parts of business law, the difference between ordinary negligence and gross negligence. Ordinary negligence and gross negligence are both negligence for which you could be sued, but the level of damages might be a little bit different. For example, if something is grossly negligence, it is much more than ordinary negligence. This is where someone is negligent, but their negligence was so willful, so reckless, that not only did you have a duty of care that you breached that duty of care, but my God, what were you thinking? Right? Racing 95 miles an hour when it just snows, that's just crazy. In situations like this, there might be punitive damages. And, we'll talk about punitive damages. In fact, there was the McDonald's case in the book, right? You can't talk about torts and not talk about the McDonald's case, right? And a case, where negligence went a little too far. Why? What happened in the McDonald's case? Anyone? Grandma goes with her grandson to get a cup of coffee from McDonald's. What happens?
She spills the coffee on herself and says
She was just trying to put cream and sugar in.
or I don't know, yeah, so she hurt herself and
Quite
she said
badly.
she wasn't expecting it to be that hot or something like that.
It was really, really hot. And this is the case that everyone says, oh my God, the jury awarded like $5 million in damages. But do you know what the backstory to all of this is? Real quickly, because everyone's like, oh, these cases are out of control. Look at the punitive damages, blah, blah, blah. The deal here was Grandma wanted to settle the case with McDonald's. She asked for like $11,000 in damages for the medical bills. She was okay, thank God. Grandma was okay. She just suffered some injury. And maybe 11, 20, whatever. McDonald's said, go away. Don't you know coffee is hot? But what it is. But when this case actually went to trial, it was like McDonald's went like nuts. It was like 200. It was so hot that it was just unsafe to give someone a styrofoam cup and give, for God's sake, if you did this and something fell out, it would really cause like third-degree burns. Why? Because they want to be competitive. Because most of us like our coffee hot. So the hotter you make it, the hotter it'll stay, and the more likely you, whatever. So they found them to be like so arrogant and so grossly negligent that the court slammed down millions of dollars on it. By the way, it was appealed by McDonald's and it was reduced to like $400,000. It was, so when people say, oh my God, look at, it was punitive damages awarded, but it wasn't like ridiculous amount. She suffered medical damages, she suffered the pain and suffering, and it was just arrogance by this large corporation. But whatever you might think of it, it was a good example of punitive damages because Grandma's injuries were a few $1,000. Grandma took home $500,000. So, what is that if not punitive damages? And the court wants to make an example of reckless, gross, indifferent behavior. Okay, what else? Concept that's thrown out there, attractive nuisance doctrine, a tort rule that says that if you're a landowner, meaning a homeowner or business keeper or someone, if you put something on your property that is referred to as an attractive nuisance, that if somebody's injured by that, you will be liable. You might say, well, that's not fair. If I own a property and I have, a pool or something, why should I be? I didn't invite that person over. Why is that person there? Well, to children, they're attracted by things. So if you have like a trampoline or something, put a fence, do something that, otherwise the law might say that is negligent on your part because children do not know the difference between safe or not safe. And if you sort of just leave it out there, you cannot expect them to act like reasonable people because they're little and they haven't developed the maturity skills and so on. that leads me to another sad case, the Toys R Us case. So here, Toys R Us imported, I think it was a slide, like a slide that you blow up that can go into a swimming pool, and they imported it from China. They didn't bother testing it or anything like that. They sold a bunch of these. One of the families that was using it pretty normally, but the individual slid down a certain way, just suffered horrific injuries as a result. And the question was, is Toys R Us grossly negligent? Not just negligent, because they have a duty of care to put safe products, blah, 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 but grossly negligent because if you're grossly negligent, the level of damage is quite a bit higher. She died. She did die, okay, it was even worse than I remember. And the answer is, the court says yes. The court says, look, you're Toys R Us. You're huge. You're like the biggest manufacturer that there is. What you put out there needs to go through some level of testing. You can't just say, oh, nice blow-up slide, let's import it from China and put it out there, and without doing any testing on it, without even doing just like any rudimentary due diligence. So it's not enough to pay ordinary negligent damages. We're going to hold you to a much higher standard of gross negligence, and there would be, real damages. Again, you want to make a case of, example of these cases. Do you have companies act in a more responsible fashion? Good Samaritan, who doesn't want to be one, right? Should you stop and help someone that needs medical help? Of course the answer should be yes. But the thing is, are you protected? If you took a CPR class 5 years ago and you wind up puncturing someone's lungs, giving them CPR, who does Good Samaritan law protect? Well, it doesn't protect you and I. It protects a medical professional. It doesn't have to be a doctor. It could be a nurse. It could be an EMT. It could be any one of those people who stop and give help in an emergency. And it basically says is that they're not liable for ordinary negligence. Meaning, if they're really trying to revive somebody and they wind up actually rupturing one of their lungs, but they save their life, they shouldn't be sued for that. I mean, honestly, there should be some limit to being a good Samaritan. So as long as they were not grossly negligent or didn't cause the injury intentionally, they are protected. Who's not protected? Laypeople. Okay. If you're not trained in CPR, don't try this. But if you are, and if you have a valid CPR, you may be protected under the Good Samaritan laws. Okay. Extra credit for those who remember this. What else? All right. Let's say it's negligent behavior. Let's say the defendant was negligent. Could there ever be a defense to negligence? Right? An affirmative defense. And the answer is yes. I mean, one example I already gave you. I was negligent, I hit somebody, but lightning destroyed their car, not me. That is an intervening event. I'm not responsible for that. It could be, it's a defense in causation, it's also a defense because it's a superseding or intervening event. The other one would be assumption of risk. Did the plaintiff assume some risk in conducting a certain activity such that the defendant should not be liable? The case in the book, the case of, I guess we're in the baseball frame of mind. The case was a fly ball case. Someone tell me about this case real quickly. It was pretty simple. Is the defendant baseball owner team liable for negligence? What happened? You're at a baseball game. You're sitting, I haven't been to a baseball game in years, I don't know. There are areas that are protected and areas that are just whatever, right? Where a fly ball can just come. And people love that, right? Because they like to catch those fly balls. But here, a woman actually got hit by the ball and suffered injuries. And she's suing for negligence. You had a duty of care to protect me, I'm here, and I suffered injuries. If it's your players that's threw the ball, you're negligent. And the question here is that, is this an obvious danger? Is this an assumption of risk? And the court says, yeah. You're buying seats, bleacher, whatever seats, it's expected that this can happen, right? I mean, pay attention, duck when you need to, because, the whole point of baseball is you're trying to hit a home run, and who knows where that ball is going to go. That is an obvious danger, that is an assumption of risk, and that is not something for which the defendant is going to be liable. And by the way, who's going to go skiing this winter? Anyone? There are no skiers here? Who's going to go horseback riding? Anyone? Those are the kinds of activities where you almost sign a waiver that says, I understand that this is a dangerous activity. If I hurt myself on the slopes, over things that you have, no control over. I mean, obviously, snow is slippery. Skis are dangerous. I could fall. That is an assumption of risk. So again, there are things where the plaintiff assumes the risk of a particular activity. All right, another defense, and this is an important one. They're all important, but this is a really important one, is, hey, the defendant might have done something wrong, but the plaintiff didn't really have clean hands either. Either they contributed to their own negligence, or you gotta look at their negligence vis-a-vis. Like someone asked me that question a while ago, like with, what was your question again? I'm forgetting. Forcible force and so on. Like, there's, it's not a negligence case there, but there's kind of blame on both sides, right? So for example, here, let's just look at a traffic accident. One party was speeding, and another party was making an illegal turn or something. Okay? They're both kind of at fault. But one party's suing the other one is filing a cross complaint, whatever. So, does anyone recover anything? Depends. Because most states have something called comparative negligence, but some states have something called contributory negligence. And if you're in a state, remember, negligence is state law. If you're in a state that says that we subscribe to contributory negligence, what that means is that a plaintiff who is even partly at fault for his or her own injuries cannot recover at all against the negligent defendant. So if the truck driver made an illegal turn and the other party was just going 5 miles over the speed limit, just 5 miles, okay, and it was clocked, let's say that, and basically that plaintiff suffered incredible injuries, and it is shown that, it really was the illegal turn that was mostly at issue here. If you're in a contributory negligence state, plaintiff gets 0, because they were sort of slightly at fault, right? That is such a harsh rule, which is why most states have done away with contributory negligence and have gone to comparative negligence. Look at proportional, right? So damage is apportioned according to fault, right? So if some expert comes in and says, really the accident was caused 95% because of the illegal turn, maybe the 5 miles an hour made a difference, 5%. So if there's a $100,000 award of damages, plaintiff can get $95,000, So that's really how most negligence is, we understand that there could be fault on both sides. Most states will look at comparative negligence, comparing the two. Some states say we have what's called a pure comparative negligence, which says that the plaintiff cannot be more than 50% at fault, because then it seems like they should get it. Right? That's at the medium ground. So will you guys remember contributory negligence, even a little bit of fault means plaintiff is out. Comparative negligence comes in 2 flavors. Pure comparative negligence means so long as, the plaintiff was less than 50% at fault, they recover something. And other states just say, look at comparative negligence. If experts say, based on fault, whatever percentages it is, that's how much plaintiff recovers in damages. Okay? And this is a very popular and very common concept to understand, the difference between comparative versus contributory negligence. Although they sound alike, they are very, very different. Did I skip something? I'm sorry, that's the partial comparative. I think I got my rules mixed up, by the way. I explained the 50% rule as if it was partial comparative. So let me back up and just kind of correct myself. A pure comparative negligence law is going to say, regardless of the percentage, everyone gets damages based on their percentage. Partial comparative negligence looks at the 50% rule. By the way, on my exam, I will not torture you like this. On the CPA exam, I cannot tell you how you will be tortured. So please understand that I want you to know the difference between comparative and contributory. But for the CPA exam, remember the difference between pure versus partial, because those are the two flavors. And the partial comparative negligence locks out the plaintiff if they are more than 50% at fault. Okay, so sorry if I misspoke there. All right, we are heading to the finish line, thank goodness. The last thing we're going to just introduce in this chapter, because we're going to talk about strict negligence next time when we do product liability in chapter 6, is, remember I said there are 3 kinds of torts: intentional, unintentional, also known as negligence, and the last one is strict liability. Strict liability is just what the name says. It's liability without fault. Doesn't matter. You injured somebody, you're strictly liable. What are those kinds of things? Certain activities that can place the public at risk of injury, even if somebody was reasonably careful. And the reason you have strict liability is because we want there to be some way to recover for those kinds of injuries. So these are like, really dangerous things like, what if someone is in the business of crop dusting or dynamite blowing, things like that. Even if you take proper precautions, but someone gets injured as a result of that, you're going to be liable, because there's just no way that kind of activity will absolve you. That's where you need a lot of insurance to cover those kinds of very, very dangerous activities, which are not illegal, they're just super dangerous.